Notes item 18 notes requesting for 1 week time notes.
Counsel for the appellant is present. A request posted to 2911. Other side counsel is there, Emma. Yes, I will adjourn it. Next.
Page number 3, 24 to 34. Page number 4, 35 to 49. Page number 5, 50 to 64. Item number 63. Point box after 2 weeks. Page number 6, 65 to 80. 79. Very good.
You are representing?
1974 petition. Very good. 2 weeks later, that I've been counsel with that. Item 68. 2 weeks.
You are representing?
68.
68 representing on behalf of the appellant.
I'm for the respondent in item number 80, Millard.
1 minute, sir. We are in 68 now.
Public.
2 weeks. I think 63 also posted 2 weeks. Item number 6.
Let the other side counsel come, sir. I will adjourn after he comes.
Items
63, huh? 63 and 68.
item 7.
Item number 70, yes.
Very posted 2 weeks later. I've been counsel. Item 71. Item 71.
See, if both the counsel are there, then only please represent. I'm not going to adjourn when one counsel requests.
No, I
time.
informed other side on like item 71.
After the adjournment, they are coming, sir. That is the
No, I
problem.
informed him. He has no objection.
Item number? You are representing 71.
I am the respondent there for petition P. Durga petition.
Both the counsel, 71. Both
2 weeks
counsel
last
present at request of the counsel for the appeal posted to
2 weeks last members.
1st December.
Watch.
Item 77. This also I'll adjourn number later.
Millard, item number 80, Millard,
80.
80.
Hmm.
I have informed the petitioner's counsel they are agreeable, Millard. I am not well. That is why I could not come to the court. 2 weeks, Your Lordship, kindly grant.
For the petitioner, my lords.
In this 80, yeah?
Yes.
Yes.
My lords,
Both
there are
counsel are present at request
interim
of
orders, my lords, that are being extended from time to time.
counsel for the at request of the counsel for the respondent posted to one full interim orders. We'll verify whether interim orders are there or not. Then
They
I'll
are there, Millard, Your Lordship, extend.
extend it till 1.
Obliged.
Obliged.
81 to 85.
My lords, item number 85 and 86, my lords.
85
I'm for the
and
petitioner. I'm for the petitioner counsel, my lords.
85.
85 and 86, my lords.
86 is petitioner counsel is Gadam Srinivas. In 86 and in 85 it is Rajeshwar Reddy garu.
Yes, my lords. B. Rajesh Reddy, yes, my lords. My lords.
84 and 85, sir, not 85, 86.
Sorry, my lords. Sorry, my lords.
84 and 85.
85.
Other side counsel is there? I
I'm
will
for the-
adjourn, sir.
I'm for the petitioner counsel, my lords.
Okay.
In 1 week time, my lords.
Okay.
Obliged, my lords.
For extension of consumer, supposed to be listed today, not listed.
This one, tomorrow. Lakshmi post for withdrawal, Your Lordship. Day after tomorrow. Please go, Chef.
And the CRP supposed to list today, not listed.
Day after tomorrow.
They are proceeding with the trial tomorrow.
తీసుకోండి డేట్స్ ఇప్పుడు ఆయన చెప్పింది టుమారో అండ్ ఒకటి ఇంట్రీమ్ ఆర్డర్స్ ఈరోజు అయిపోతుంది ది ఫస్ట్ వన్ టుమారో మణిదీపిక అయితే మండే ట్యూస్డే ఎస్
Number 1, right? Number 1, then 1 over.
CMA 1003 of 2009. CMA is dismissed.
Apply.
CRP 2270 of 2014. The impugn order dated 15/4/2014 in EP 5 of 2013 in OP 19 of 93 on the file of learned First Additional District Judge Nizamabad. In all other aspects, the civil revision petition is partly allowed by setting aside the impugn order only to the extent of awarding interest on the solution in favor of the claimants. There shall be no address to cause.
Oblige.
Vipan.
On the contract, there is no guarantee put prior to the lot. Since the time of the civil and final report.
This matter will, there is no interest and there is no death certificate.
Recording. causalist of this.
The fourth, to cover it, is which one?
Lordship, I am representing on behalf of appellant Lordship. The counsel on record is not well, Lordship, since long time he is not attending. I have informed the company and I will appear on behalf by next week, Lordship. Maybe removed from the caption of dismissal and post for next week, Lordship.
No, in the last occasion, Sheetal Kumar said he is filing wakalat on behalf of the appellants. One Sheetal Kumar, counsel.
I am not aware, Lordship.
It is on the proceeding sheet, in the last occasion he has represented that he is going to file wakalat,
Yes, Lordship.
but has not turned up. It is under the caption for dismissal.
dismissal.
I'll dismiss.
Much all.
Let him
Lordship
come.
may be permitted to appear at least, Lordship. Next week I will take up at least. Because
Okay.
already the stay is granted on behalf of insurance company. The balance amount has to be disputed, Lordship.
See, he already represented and stated that he is going to file wakalat. Now I cannot mention your name in the proceeding sheet. Or else I'll pass over the matter, let Sheetal Kumar appear.
Yes,
Because he
Lordship.
already represented that he is going to file wakalat.
Yes.
But
I'm
he
not
didn't.
aware. In case if it is like that, he would have filed the appearance at least by this time.
I'll see, I'll pass over the matter and then.
Yes,
Thank you.
Lordship.
I'll inform
Yes.
Sheetal.
Much obliged.
Next.
Much.
Five.
May it please your lordship, I am appearing for respondent 2, that is an Oriental Insurance Company. On behalf of my senior counsel, Batula Rajkiran.
Who is the counsel for the appellant in this matter? His name is not printed.
From the last 2-3 occasions, they've been not appearing,
Why
your
the
lordship.
name of the appellant is not printed here? No representation, though notice was sent by the registry to the appellant, notice was written under learned counsel as a case of respondent and dismissed. Since there is no No, actually what happened was we have issued notices to the appellants, but they have not turned up despite receiving the notice.
Yes, your lordship. It's
Let
been
me
2-3 times
notice.
that
Why
the notices has been issued.
Battala Venkateswar Rao? You are representing Battala Rajkiran,
Yes, your lordship. The respondent to the Oriental Insurance Company.
Notice sent to appellant has been written answered. Written answered. What is the reason for answer? So notice since not written. ఈ పేరు గల వ్యక్తి రామపురం డాక్టర్ ప్రిస్క్రిప్షన్స్ లాగా రాసిస్తే మనకేం అర్థమవుతుందని ఎందుకు పంపుతున్నారు? రీజన్ ఏం లేదు. అడ్రస్ చూద్దాం. జి రాఘవులు సన్నత్ సొంసో ఏసెక్కి లారీ డ్రైవర్ నరసరంపేట. Actually, what happened was counsel is no more. Counsel for the appellant is no more. For that reason, we have issued notice to the appellant. Sole
Yes.
appellant. From that day, actually, see what happened for the respondent number. You are representing respondent number 1 also.
No, your lordship, just respondent number 2, the Oriental Insurance Company.
Actually, what happened was The case against respondent number 1 was dismissed for default for non-compliance of the order. Non-compliance of the order dated 5/9/2011. 5/9/2011. The counsel for the applicants are permitted to take fresh notice and fresh notice concern correct address.
Actually, this appeal is filed in 2007.
2011.
Yes, Your Lordship.
2011.
And they were asking for enhancement, Your Lordship. Like,
Actually, see, the directions have been given in the year 2011. After that, the case has not been listed till 2023.
yes, Your Lordship.
In the meantime, the counsel for the appellant is passed away and we have issued notice to the appellants. And
I may be
it is
allowed to
written-
make my submission, Your
It is
Lordship.
written, it is written answered without any reason and not assigned any reason. Address is same. We can treat it as a deemed service because the address what is mentioned in the application is same. And then notice address is also one and the same. So are the applicants? Of the applicants. Applicants.
I may be allowed to make my submission, Your Lordship.
Yes. No, what we have to issue notice to them. This is the application filed by the applicants,
Yes.
not by insurance company also. The address, what it is mentioned in the application has been given in the notice also. Same address. Notice
Yes,
has
yes.
been sent to the same address, but it is returned without stating any reason. No door number, nothing. Name, age, and father's name and village. That's all. It's not possible for the postal people to serve the notice. ఏం చేద్దాం ఇది? We'll do one thing. We'll issue fresh notice again.
Yes, Your Lordship.
KLN Rao garu is having any juniors? KLN Rao garu.
I'm not aware of that, Your Lordship.
KLN Rao. Yes. Juniors.
No,
పార్టీస్ అన్యాయం అయిపోతూ ఉంటారండి.
no juniors.
They are not able to 2011, it's not a recent case also. And respondent number 1 also has not complied the orders. For that purpose only, it has been dismissed. Later, I do not know what happened. All of a sudden, it has been listed.
Yes, Your Lordship.
For all these years, we'll take a chance again. Issue fresh notice to
Yes,
the
Your Lordship.
issue fresh notice to the appellant, sole appellant. Only one appellant is there. Through court appeal.
Highly Your Lordship.
Counsel for the respondent 2 respondent number 2.
Yes, Your Lordship.
Respondent number 2 is present. Posted to the Hyderabad on 30/30/11.
Highly Your Lordship.
They dismiss him. In spite of opportunity given, the appellant has not submitted documents. As the cases of the year 2011, CM is dismissed for non-prosecution. Next. Next. Hmm. 18 matters అన్ని కూడా CRP 1475 of 18 and CRP 6865, 6699, 68656. All these 18 matters, no? On these 18 matters, I'm deleting from the caption for orders and posting before the courts, which is having the roster. Because we do not have the roster, why should I?
Oblige.
I'm releasing all this. CRP 1475 of 18. CRP 6865. 6699. 6856. It is posted for orders, but I have not made ready actually. See, we do not have the roster. Why should I take up all this case?
Oblige.
Placed before the regular court as per roster.
TRP 9, 10, 11, sir.
Yes, 1 minute. Item number 12. 12.
9, 10, 11 has not been found.
They are released, sir. 9, 10, 11.
Yes, my lord.
Roster లేదు మనకి. We do not have the roster. Roster has
Obliged.
changed. You understood? Yes. 12. Request of the council for the appellant posted to 2211. Item number 12, morning, you have requested time on behalf of Chandrasekhar Garu. Yes,
Oblige.
2211.
It is coming for orders.
Hmm?
It is coming for orders.
Thanks for orders. Orders, huh? Anant, but you requested time, no? You are representing
And for respondent, you have
respondent. Morning, someone requested time.
oblige.
Okay, 22. Yes, item number 13.
Yes, Miller. May I please, Miller? I may be
Yes.
permitted to appear online, Miller.
Yes.
I
Yes.
am for respondent, Miller, in this case.
Hmm.
So as it is posted for orders, Miller, and I have apology, last occasion I could not represent before this on court, Miller.
Yes.
So if petitioners argue, I will commence the argument.
No representation for the petitioner.
Yes, Miller. The trial has been already commenced and defendant's evidence was also closed in this case. Suit for injunction, wherein an application was made under Order 26 Rule 9 for appointment of commissioner in injunction.
Yes.
So that was dismissed.
Harpreet case. Yes.
Today my friend is there.
Is there online?
I am online, Mr. Harpreet, now today. I am not feeling well.
The petitioners are the plaintiffs, Milad, suit. But they filed the Milad application under Order 26 Rule 9, Milad, seeking appointment of advocate commissioner. But they are claiming the property in survey number 67, Milad. 67, Milad, to extent of acres, 1 acre 17 guntas. Peddambarpet village, Milad. Whereas the respondents, Milad, initially, Milad, after filing the injunction, the status quo orders were granted. But main contention in my suit is that, Milad, under the guise of Milad survey number 64, Milad, respondents are holding, their properties are in survey number 64. But they are, Milad, encroaching into, Milad, our survey number. Therefore, Milad, to restrict them, Milad, we file the suit and we obtain the status quo orders. Thereafter, since there is a dispute with regard to the, Milad, survey number, Milad, since they are claiming under 64, and we are claiming under 67. To, Milad, for the purpose of localization of that survey number, but we sought the appointment of advocate commissioner. But the court below, Milad, Lashma, can you see the order? The page 11. But as per the contention of the petitioners, the Lordship got it. The petitioners and their cousin brothers got partitioned their ancestral property in survey number 47, 48, 67, and 64, 64 by 2, 64 by 3, Peddambarpet. It is also contended by the petitioner that 1 acre 17 acres was allotted to the petitioner in family partition and they converted the same into house site. Further contention of the petitioner is that respondents are neighbors in the respect of plot number 110, 130, 131, 142. The allegation of the petitioner is that the respondents are interfering position of the petitioner, therefore they seek to appointment of advocate commissioner. When it is categorically stated by the petitioner, the respondents are neighbors with different plot numbers, what will the advocate commissioner do at the scene? And what fruitful purpose would be served when the interference as alleged by the petitioner is to be proved by the petitioner in the main suit. It is not a suit for declaration of the title or boundary dispute for the advocate commissioner to go to the site and measure the land. It is simple for injunction. The documents speak by itself. The advocate commissioner cannot go to the site and help the petitioner in measuring the land because in a suit for perpetual injunction, it is only the lawful position of the petitioner and cause of action which are to be proved by the petitioner in the suit. From the record, it is seen that they having obtained ex parte injunction, the petitioners have been dragging the matter by filing this application. The caution is given by the petitioner that the relief of perpetual injunction is relief of equity. It cannot be granted the persons who approaches the court with unclean hands, malafide intent. Therefore, the petitioners are at liberty to proceed with this suit. The advocate commission neither can prove the help the petitioner to prove their position or can prove or help the petitioner prove cause of action. Under guise of this, evidence cannot be collected by the same routine reason if the application is allowed this amount to collection of the evidence. But the number of judgments are there, even the recent judgment of this honorable court. Since there is a dispute with regard to the boundary, but since we are claiming under 67, but they are claiming under 64, on the western side, since there is allegation that they are encroaching into our land, but therefore the petitioner has filed the application seeking to appointment of the advocate commissioner for the describing the property. What else? Two 2015 to ALD Milad. Para 25 Milad. There is no absolute bar on appointment of a commissioner in the suit for injunction, also as per the law laid down in the above report judgment, nor the provisions section 75 and order 26 rule 9 do impose such a provision. The respondent plaintiff filed the present application for appointment of advocate commissioner to note down the physical features of the scheduled property only and not for the purpose of finding out who is in possession of the property. The court below recorded valid reasons for appointment of commissioner. The court below in the considered opinion that this court is perfectly justified in appointing the advocate commissioner, and the said order is in accordance with the principles laid down in the above report judgment. Therefore, the order under revision has neither suffer from any fundamental infirmity nor any jurisdictional error, which warrants interference of this court under Article 227 of Constitution of India, taking into consideration of it all. Well, just to since we are claiming 67 minutes, the dispute with regard to the western side boundary, even as per admitted case of the respondent, they are claiming the 64. To determine the said fact, we sought for the appointment of the advocate commission. What has to say?
At least say the citation. Council is also online.
Since my friend is online, I send it.
You already sent WhatsApp.
That's his number. Division bench of this honorable court judgment 2026 ALT page 99. This case also made the dispute with regard to the survey number. Page 30, para 37.
Paragraph?
Para 37.
37.
Paragraph 37.
You have only 20.
2026 ALD 9.
Where you got the para 37?
Your internal page 104 million.
Okay, two cases you have.
What next case, Milad, Milad Ariba is the direct.
You have, okay, that you have attached with this, it is only 23 paragraphs, okay.
23 is the arranger judgment.
Yes,
right?
37.
When the appellants are claiming the land in survey number 85/1, a separate subdivision in survey number 85, and the respondents are claiming land in survey number 85/2, a different subdivision in the same survey number. It was incumbent on the part of the court below to first appoint a surveyor in IA number so and so, on the ground and the plain schedule and localized as was sought by the appellant. In Haryana's Waqf Board, that judgment also. What else? The Supreme Court held that if it was a case of the demarcation of the disputed land, it was appropriate for the court to direct the investigation of appointing a local commissioner under Order 26 Rule 9 CPC. In Badanam, Mutyalu and others, so this court has held that the situation where there is a controversy as to identification, localization of measurement of the land, local investigation should be done by the appointment of advocate commissioner. This was reiterated in Jajula Koteshwar Rao versus Ravulapalli Mastan Rao. So, the local investigation under Order 26 Rule 9 CP is to collect the evidence at the instance of the party who relies on the same and which evidence cannot be taken into the court but can be taken only from the peculiar nature on the spot. This court held that the commissioner in effect is a projection of the court appointed for a particular purpose and where there is an allegation of enforcement by one party which is denied by the other. Oral evidence cannot be come to an aid of a party. An advocate commissioner may be appointed as a ascertain this fact and that.
What is the stage of the suit now?
Suit Milad trial.
It's commenced.
Trial Milad. Now only to Milad for the helpful to, it is helpful to the court Milad if the dispute is Milad resolved. But if the localization is done by the advocate commissioner. Since Milad at different Milad, we are claiming this 67, their claim is 64. But when there is allegation that they are encroaching into our land, is suit for injunction. But it is necessary to appoint the advocate commissioner. Whether Milad they are under Milad, they falls under 64 or 67. If the Milad they are not coming into 67 Milad, they ends the matter. Since there is a specific allegation, western side boundaries towards western side, they are encroaching into our scheduled property in survey number 67.
Yes.
There is no absolute bar in appointing advocate.
No, but I'm just thinking,
Since there is a
this trail has commenced already.
Yes, that's right.
And
Moreover, it is an injunction.
it is helpful for the petitioner. I'm just thinking of that. Let us hear the other side also. We'll find it. Yes, sir. Counsel for the- Yes.
Maybe. Your Lordship may kindly consider page number 14, Milord, of the petition filed by the petitioner. At page number 14, para number 5. The reasons mentioned by the petition for appointment of the commissioner is stated in the petition at para number 5. I further submit that the respondents are also our neighbors on western side of my property in respect of their open plot 130, 131 and 142, consisting of 300 square yards each, forming part of so and so survey number. Taking advantage of the same, they are trying to encroach into my property on western side. I further submit that after filing the above suit, this on court pleased to grant status quo and posted the matter. I further submit that until and unless conduct the survey with the help of advocate commissioner, I am not in a position to protect my property. So that is the reason stated by the petitioner. Protect my suit scheduled property as a matter is in urgent nature. I further submit that I am ready and fulfill the requirements of the expenditure. So this is the reason mentioned by the petitioner for appointment of the commissioner. And Lordship may kindly consider, admittedly, he is the owner of the property for all the survey numbers. that is 64 by 1, 64 by 2, 64 by 3 as per as admission, along with survey numbers 47, 48, 67 also. So he said that in partition he got 67 to the extent of 1 acre 17 guntas. So my submission in written statement is that, my lord, that entire land is converted into plots and already sold away to the different persons. That a written statement also filed by my friend himself, which is at page number 23. So your last may kindly go to page number 26, para number 8 I have stated and narrated all the facts with regard to that survey numbers, how that survey numbers were sold to the different persons, and there is no land existing. I will not trouble this on court with reading all this thing, my lordship. And your lordship may consider, while passing the orders, this para number 8 has to be taken into consideration. So that is my submission. And other thing, my lord, that the prayer of the petitioner at page number 16, petition prayer, your lordship may kindly consider. And I am permitted to read.
Yes, yes.
Here, they have stated, my lord, only with regard to appointment of commissioner, but there is no schedule given to the petition. So there is no boundaries mentioned. So for the case of the petitioner, your lordship may consider that the western part is encroached upon. So there is no schedule mentioned and boundaries were also not mentioned in this petition.
This suit
So,
is for simple sort of injunction.
Suit for injunction.
Why fixing of boundaries with the help of the mandal surveyor?
Yes, that's what.
Why this prayer? Why this has been included in the prayer?
They are not definite. In identification of the property in dispute now, they want to prolong they want to gather the evidence by appointment of the commissioner. So the lower court was correctly considered the same and dismissed. That is my submission.
Okay. It is only for identification of the property, right? But why to fix the boundaries with the help of the mandal surveyor? It is not what we call it's not a declaration suit, nor what we call.
Recovery of position or declaration of title.
It's not.
Saying that we have sold out the entire property, but we are not alienated any property to any third party. Entire extent.
That is subject to suit, my lord.
That is evidence. So fall into the share of petitioner plan. They have remained as they are not sold any piece of land. And now we let other guys of 64, maybe we let another we let the advocate who has sold the land to the third party, that they seem to be purchased from from them in that survey number. Now we let the western side not their interpretation with our property. The civil schedule property that
And can the court rely upon the adequate commissioner's report? You tell me. When the trail has commenced.
No.
That is only identification of the property. But you have stated your prayer has crossed the identification and went to the extent of stating that fixing of the boundaries.
The PW one was
It is
cross-examined.
it's only an injunction suit. You have to prove your possession. It's not specific performance or the declaration or the record of possession. It's nothing. It's a simple injunction suit. Anyway, I will.
The converted saying outside, but not alienated the same to any third parties, as we have retained the same for our family member. That they filed the written statement stating that their cards are situated.
Yes, yes, towards the western side. See, the disputed plot is 67 or 64
60.
property. Okay. See, there's no dispute regarding 64 by 1, 2, 3. All this, you are admitting that these survey number plots belong to the respondents.
Yes, 64 belongs to respondent. And my specific belongs contained in the claim for the that will have to extend side and the guys are 64, they are encroaching into my land. But they're claiming Milad, as it Milad, they are the owners of this plot in our survey.
Your survey number is 67.
Schedule Milad, every petition Milad, since schedule property.
Where is the schedule?
Page 36 in the claim that file.
Page 36. Survey number 64 north to neighbor's land. So south is neighbor's land, which is respondent's land. South.
Neighbors are other parties.
Other parties. East land in survey number 121 bank colony. West is 64. North and west is 64.
Here Milad, western side, Milad, enforcement, fighting the respond. Then after filing in letter, written statement, the disputant Milad, my title saying that I have alienated the entire part. But whereas I am in position of the 67, I protected my property. Entire extent it was allotted as a partition deed to my family. And now Milad, they are enforcing into my property instead of granting status quo. Therefore, they have become lesser to Milad filing the application. And before the trial court, fixing appointment also will take place.
Heard both sides for orders 2411.
Achha.
File ichchesend నాకు 2411. Yes.
15 and 15. Yes, which we found, moving on.
May it please your lordship, I am for the respondent in both CRPs, your lordship. Last occasion we advanced, both sides advanced arguments, your lordship. It is only the issue is before this honorable court is Malot for appointment of Advocate Commissioner Malot. The lower court appointed Advocate Commissioner Malot, challenging the appointment of Advocate Commissioner Malot. The petitioners filed the CRPs Malot. The only point raised by the other side counsel Malot, last occasion Malot, whether the court below is justified in appointing an Advocate Commissioner sumoto. Last occasion I have argued Milord before the honorable court Milord, they themselves requested, they filed an IA Milord, praying Milord appointment of Advocate Commissioner Milord for identification of the properties Milord. Even I have submitted an application before, certified copy Milord before the honorable court Milord. They say that Milord, that application was filed in suit Milord, not in CMA Milord. Even Milord, the lower court Milord called for entire record Milord and appointed Milord an Advocate Commissioner Milord, and by way of common order Milord, and both the CMS Milord appointed an Advocate Commissioner Milord, because they have raised an objection for identity of the property Milord. The suit itself Milord bare injunction Milord.
Yes, I remember. We could have heard both sides for orders 2411. 2411 for orders.
Obliged.
See, here, follow the this. Maybe.
Yes. Well, counter. Counter has to be filed. Proceeding sheet. Proceeding sheet. No proceeding sheet. Both counsel are present. Shall I give directions? No, shall I give directions to the council to serve the copies, to furnish everything? Shall I? It is the duty of the council. Huh? Every time the other side councils in other cases also requesting for furnishing of the copies. Furnish immediately. Without going to the copies, how can they contest the case? Furthermore, they are caveators. They have filed caveat petition also. Both counsel are present. The counsel for the appellant is directed to furnish the copies to the respondent. What is the suit for? Suit is filed for? Suit is.
According to their condition, the future properties ancestral of the ground. They are filed with documents, but every document will not mention the grant of the trusting the properties ancestral.
What happened to the suit? Is it decreed?
3 months. Say that should be divided into 7 parts.
Dissatisfied with the share of the. Okay, 512. Is there any urgency? Amma 2023, no? They will serve the copies in the meantime. 2023 matter, Amma. What is the urgency? I have posted to 512. 512. Is there any urgency in this case? See, I am not even granting stay. Okay, they have filed an application 1 of 23. I am not granting stay also. Okay, if there is an urgency, I'll post it to 23. 23. Then? Okay, 512. In the meantime, today only you saw the copies. Okay, next.
7 Kalyan.
In this, we have to issue notice. Condone delay petition is there. Condone in representation. Counsel for the appellant is present. Issue notice to the respondents. The court RP. Personal notice is also permitted. Posted to. Why? Is there any injunction before the trial court? One second. Yes, got it. Yes.
Lakshmana has Diluted the bill in my favor. But Narayanamma is my daughter. Specific contention is, even though the land is belonging to me, even you of my old, Dr. Narayanamma is my daughter. Here 16 years of justice. Item 4. We did execute it. We get a Nothing is stated, nothing is recorded in the document. Simple statement for me, stating that the unreported and there is no record. The other record is not revealed by either party. No issue is framed, no contentions, no evidence was taken. Duties while seeking declaration of title.
Yes. I'll put to a short date. It is Kottagudem, Bhadradi Kottagudem. Issue notice to the respondents. Twenty-three eleven. Both parties directed to remain. Issue notice to the respondent. Personal notice is also permitted. Both the parties directed to maintain status quo.
In 90, Laterally Danish.
No representation for the appellant. Issue notice to the respondents through court RP. Posted to 7th December, 7/12.
Number 20, Surya Satish.
This matter I'm appealing for the counsel for the appellant lordship, Mr. Zakir Ali Danish lordship. There's a delay in filing of the appeal 70 due to his list.
Yes.
There is a delay of 72 days, dear lordship.
Yes, we have already issued notice to the respondent. 7/12, Amma. Date is 7/12. Yes, next matter. We are in item number 20 now. Yes. GP for arbitration. Counsel for the appellant is present. At request posted to 4th December.
22, 22, 23. Total increase for all, then
21, 22, 23 and 24. Yes. See, when stay is granted, you always seek adjournment. And the other side counsel insists for speedy disposal and you always take adjournment. What is this suit is for CRP? Let me see. It's a reopen petition and to send B1 along with admitted disputed signature. Fingerprint expert for compare. Simple cases, why you're taking time, Amma? What is the stage of the suit? What is the stage of suit in the trial? As a last chance. As a last chance posted to all these 4 matters. All these 4 CRPs is filed for reopen petition. All IAs are for reopen only. And send the document for the fingerprints or opinion or something. Expert opinion. We'll dispose of the case. Why 20? What inconvenience, Amma? As a last chance, otherwise I'll pass the orders. I am posting for orders only. She's junior counsel. I cannot insist her. That's the problem. Yes. See, I'm on 2011. I'm posting only on 2011 at your request. You have to get ready on 2011. Otherwise, I'll pass orders on 20. Extended till then. Next.
Even 25.
Kari Murali Krishna garu. At request. No representation for the appellant on call. Counsel for the respondent is present. As the case is of the year 2010, as the appellant has not submitted his arguments, it is posted under the caption for dismissal. On call on 22/11.
22nd, 27th, Uday Shri, Mahendra Reddy.
Mahendra Reddy garu. I am saying there actually. Yes. Huh? Uday Shri, yes.
Ravi Kumar.
Notice sent to respondent number 2 has been served. Notice sent to respondent number 2 is served. And Pavan Kumar is for respondent number 1, 3 and 4. Notices have been served in all to all the respondents. Okay, GM Ravi Kumar, you're representing?
Ali number please find in the LR point number 1 of record evidence. As per the details of the particulars provided by the respondent number 1, we have sent out notice to the since the notices have been returned
Notices in IA 1 of 23 have been sent.
Yes.
What happened to the notices?
One notice has returned on the ground that said return to sender. And returned with an endorsement by addressee and its left over. We'll also be kindly to do standing up with the file application for something. And choosing the particular provided by the respondent.
Okay. Counsel for the appellant is present. No representation for the respondents. Respondents 1 to 3. However, notices to respondent number 4. Only 4 has been returned. Only 4. Notice to respondent number 4 returned as a death return to sender. 1 to 3 B. Srinivasulu has filed vakalat. One also died. Okay. And 4 also. Okay. For filing substitute service petition at request posted to, you wanted to file substitute service petition at request posted. When are you going to file? 28. 28/11.
30 and 31. Bro, Magi floor of like for the appellant, what the case that was
30, 31.
common judgment. Case 470D. There is out of change and so. Case 476 and out of declaration. Common judgment was passed. In case 473, I filed the document. That they have to file counter. What happened? Decision document was filed. In idea documents were marked. And you make to both sides that document was not marked. Knowledge, we taken the document from still.
Is it order 41 rule 27 application?
I filed before your. That is pending. Counter has to be filed.
Yes. Nageshwar Rao, Pakku. No representation for the respondent on call. Counsel for the appellant is present. For filing counters in IA 2021, 2020. If any, posted to. 29/11. 29/11. No. Date. When it was 3/2/2020 heard both sides. Both parties are directed to maintain status quo in respect of the social property in all respects till 24/2/2020. Okay. From that day onwards, there is no extension. You file an application, I will start. 29/11. No representation either side on call, hence posted to 6/12.
I beg to represent Mr. L. Prabhakar Reddy. This matter was allowed on 31/20/23. The clients have taken the file. Notices have to be issued in the IAs.
Other side, Mahmoud Aligar is there.
Yes, ma'am. They have filed a review, after allowing of the CRP with a condoned delay petition. Matter was allowed on 31/20/23.
These applications are ordered.
No, notices have to be issued.
1 of 23, 2 of 23,
Yes,
3 of 23, 4 of 23.
Notices have to be issued to the clients, because matter has been disposed of. They've collected the file from us. We no longer represent.
Yes. Mic on.
Instructions are stated. In 2022. 8/11/2022. And message discourse of 31/2000. After his death. Therefore, about it. Instructions are taken. This is right to go to court. They are finding a butcher. They are finding whatever they are sensible. So when the questioner, if you know the find the vendors, there are no consequences.
And
It's past. No, but we can't figure out.
On death person. Hmm.
That's my first. Therefore, taking out the file.
Hmm. Hmm.
Persons I'm saying.
Hmm.
They are making constructions.
Let notices be issued, my lords, because I cannot take notices without instructions.
Constructions.
Why the review petition is filed, sir?
Yes, my lord.
Because you are not aware of it.
Okay, okay. After the death, the order has been passed. Order has been passed again. Despite having knowledge, you have not taken any steps. That's what. At least file counter, sir. File counter. And you have to file counter in review petition.
Yes, I do
Review
not-
petition has been filed by the respondents. So you need to file counter and review petition.
Yes, my lords. In fact, let notices be issued even in the review petition, my lords, because the clients are no longer with us. Because the matter was
You have given up the
allowed.
wakalat.
Yes,
You
on
are
30.
representing L. Prabhakar.
Yes, my lords.
You are L. Prabhakar.
No, my lords, I am his junior. My lords.
Okay.
On 31/20/23, the matter was allowed, my lords. After the matter was allowed, after
Now,
6
at
months delay, my lords.
At present,
My lords.
you have given up the wakalat.
Yes, my lords.
L. Prabhakar.
Yes, my lords. We need to issue fresh notices to them, my lords.
They say they have given wakalat.
Once the matter is allowed.
They say they do not have the wakalat right now. They have given up the. Well done. Ask Rahul. Rahul. Counsel for the revision petitioner Sri L. Prabhakar represented that they have given up wakalat.
As the matter was allowed on 31/20/23.
Respondent of filing. Hmm. The presidentship. Has given up wakalat, hence issue notice to the revision petitioners. Report are two. Report are two. Posted to Lokra Rangareddy. చూద్దాము 22కి వెళ్దాం 22/11 అలాంటప్పుడు నేను ఒక స్టే పిటిషన్ వేసుకోవచ్చు కదా రెస్పాండెంట్ నాట్ టు యూ కెన్ ఫైల్ అన్ అప్లికేషన్ ఫర్ నాట్ టు మేక్ ఎనీ కన్స్ట్రక్షన్స్ అండ్ యూ హావ్ నాట్ ఫైల్డ్ అన్ అప్లికేషన్ బికాస్ issue notice to the revision petitioners 22/11 22/11 22 సార్ కనపట్లేదు 22/11 because see, we need without issuing notice, you are only a revision, you have filed a revision petition. Everything is over already. The CRP has been disposed of. Nothing is there. Yes, that's the reason we are issuing notice. File an application, sir. I will allow. Only based on your oral submissions, because CRP is already disposed of. Disposed of. It's nothing is there. Yes. And
CRP.
furthermore, you have filed the revision petition. Okay, 22/11 on that notices may not be served, sir. Rangareddy. It should go to Rangareddy. Okay. Okay. Friday means tomorrow 10. Wait, sir. Mention just wait. This next.
I beg to appear on behalf of the petitioner counsel. This matter pertains to the custody of minor child.
Custody of minor child has become major. By
Oh my God, he is right now. He might be some around 7 or 8 years.
Because all these cases, what we are taking up,
On the last occasion also, when I was ready for the matter, your lordship had adjourned the matter that because counsel for respondent was not present on it.
No representation on behalf of the respondent at request of Ceylon Council for the urging petition. No representation, no representation. Actually, there's no representation either side in all this adjournments. You have also not represented. It is interim custody, no?
IA was filed in FCOP, my lord. FCOP was filed by the husband for custody of minor child.
Yes.
And wife stays abroad, my lord.
Wife
She's
stays
working.
abroad.
Yes, my lord. On behalf of her GPA, who the petitioner, now in the CRP is mother of the wife, my lord. She is the GPA of the wife, my lord. She has contested the said FCOP, my lord. And she has even filed a counter, my lord. Your lordship may come down to para number 3 of my affidavit, my lord.
The other side counsel is not there. I cannot pass orders also, even if I hear. Petitioner is entitled for interim custody of the minor son. However, petitioner shall not disturb the academic care of the child in education, shall consider the interest of continuing studies in the same school. Petitioner shall also allow the applicant whenever child is instructed. This order shall remain in force until further orders.
Without any grounds, they have allowed the IA, my lord. Custody of child allowed to respond on the only ground that petitioner is said ex parte and her daughter is abroad. Was not allowed on any merits.
But they are natural, biological parents. They have every right over the child, right? And the paramount consideration of the child is also important.
Oh,
What is the age of the child? 7 years.
At the time of filing, he was 5 years. 8 years.
No representation for the respondent until counsel for the revision petitioner is present. Why vacate stay extension petition? Why stay petition is filed in custody of the child?
For custody, your lordship had put interim order. Stay was granted.
Stay for what?
For not to take child into custody from his grandmother.
Have you filed any application for visiting rights or something like that?
Before the lower court, I have to take instructions for that.
That is better instead of asking for interim custody, because the psychology of the child is also we have to consider. 7 years means now.
Even in the vacate petition which they have filed, my lord, they have included all the serious and false allegations against the petitioner.
That is okay. That is okay. It depends upon the parents, but we have paramount consideration of the child is more important in these kind of cases.
Your lordship may decide the
Cannot
matter
be
after
taken
hearing.
like in ordinary cases. Yes.
Your lordship may take a decision after hearing both the sides.
Okay. No representation for the respondent. Counsel for the revision petition is present and posted to a shorter date. Okay. 17/11.
Much okay.
In this minute, I am appearing for the appellant minute instead of a Jayanti minute. All matters of Jayanti were transferred to me. The minute your lordship may direct the registry to print my name. However, I am ready to argue the matter now itself. Minute. There is nothing in it. This is a case, the appeal is preferred by the insurance company under the Workmen's Compensation Act. In case of injuries, claim is 1 lakh. Awarded amount is 73,246. The appeal is filed on the ground that the cleaner was driving the vehicle. That is why there is no relationship between the employer and employee. For that matter, the insurance company has not produced any evidence. And the FIR was not filed, nothing else. There is nothing in it, your lordship. May dismiss AC. CMA. Nothing in it.
Okay. Dismissed. CMA 35 is dismissed.
Well, my name is heard Mr. Ramulu just.
This is directed to delete the name of A. Jayanti and print the name of C. Ramulu Gara.
Yes, yes.
C. Ramulu.
Obliged.
As counsel for the appellant.
Please.
Next. Rahul T. Ramulu. Yes.
Only one round.
Hmm.
Whether the person died due to heart attack is entitled for the case. Last point, kindly see the feelings of the petitioner. They have not stated in the pleading that he has died due to cessation state anywhere in the pleadings. Even in the chief affidavit also may not. There is no belief that this is died due to cessation state. The facts of the case is that my lord, he died while he was adjusting a rope. Fell down. And my lord, subsequently they claimed that this is died due to heart attack in the chief of it. But not due to cessation state. Directly I'm going to find. I'm relying on judgment of Supreme Court here, my lord. There is one more case of similar case, but nobody is there.
He's good.
Copy. Copy ada. ఒక కాపీ చేస్తే చెప్పి ఏం చెప్పిండు అది.
My lord, the factors that need to be established, leading and proofs, will only because the person died of heart attack, the claim does not give rise to returning to permission. If the claim was solved by way of an act. And the relevant para is the para 16, madam. Before we analyze the provisions of that, we may notice that in the claim petition, there was no allegation that this is met with its by reason of the strain of work. Appellant has no personal knowledge as regards the quantum or nature of given show. The system is the more relevant. And secondly, my lord, there are 17. The disease was admitted suffering March attack. Heart attack. Nothing had brought on records to show that heart attack was caused by doing any job. Even according to the entire, at the relevant time, nearly getting down from the day. 19 grams.
What is the occupation of the?
He is a driver.
In this case, is also driver, huh?
He was getting from the
Driver of the vehicle who was
but in this case, he is not driving at the time of the accident. Para 19 minors, sufferance of heart disease among young person is not unknown. A disease of heart may remain undetected. A person may suffer so. There must be some evidence that the employment contributed to death of the disease. Then, in this case, there is no evidence that because of stress and strain he died. And lastly, my lord, para 22, my lord. Para 22, the onus is upon the applicant to show that it was the work and the resulting strain which contributed to the aggravated injury. My lord, they have not proved it. because of some problem he has sustained a heart attack. And para 24 also may not. There is a crucial link between the causal connection of employment with the such a link with evidence cannot be a matter of conduct. If finding is other without leading or legal evidence, the statutory authority will commit a judicial error while the exchange of judicial. But not to be clearly says judicial error. When the cause of a death was not proved, and his onus lies on the applicant to prove it. And even section 40 mega. A judicial person will involve a substantial question of law. A finding of fact error that without there being any evidence would also give rise to substantial question of law. And the substantial question of law is very much there, madam, because there is no hiding on that. Hence, the appeal is has to appeal has to be allowed.
May it please your lordship.
One High Court was not allowed. It's also said in the same area.
Supreme Court and High Court.
One High Court.
Supreme Court is high law of the land. Inka niku.
Yes.
My lord, the very contention of my learned friend is your lordship observed on the face of pleadings and the your lordship the case of the petitioner is that your lordship while he was driving while he was working on the lorry, he parked the lorry, he took the lorry to the transport company where he loaded the vehicle, loaded the lorry with a parcel, and he was adjusting that parcel with a rope. So by pulling the rope, your lordship, he fell down. That itself speaks volumes of the stress and strain. Because of the stress and strain, he died. Your lordship, nothing has to be pleaded or proved. The very fact of the accident itself speaks volumes. The FIR itself, they have stated, your lordship may please to see, I will read the FIR. నేను అనగా పిల్లివేముల గోపాలరావు అప్పారావు సన్ ఆఫ్ అప్పారావు వయసు 29 వృత్తి అన్నపూర్ణ లారీ ట్రాన్స్పోర్టర్ లక్ష్మారెడ్డిపాలెం హయత్ నగర్ మండలం సో అండ్ సో తమరితో మనవి చేయనది ఏమనగా తేదీ 9/2/2008 నాడు రాత్రి 10:30 గంటల సమయంలో మా ట్రాన్స్పోర్ట్ దగ్గరికి లారీ నంబర్ ఏపీఎస్వి 378 గల దానిలో డ్రైవర్ ఈశ్వర్రావు క్లీనర్ శ్రీను శివరాంపల్లి నుండి వేస్ట్ పేపర్ లోడ్ తీసుకొని వచ్చినారు. మా ట్రాన్స్పోర్ట్ ముందు లారీ పెట్టుకొని లోడు సరిచేసుకొనుచుండ్రి. అంతలో ఈశ్వర్రావు తాడు పట్టి గుంజుతూ లాగుతూ కిందికి పడిపోయినాడు. That itself shows that while he was pulling the rope to adjust the load, he got stress and strain and he got heart attack and he died. And what my learned friend says that judgment is in my favor because their lordships same judgment 2007-11 Supreme Court, that was a cleaner case where cleaner your lordship during the travel he got a heart attack and died. So the Supreme Court held that there was no pleading that there was a stress or strain caused to the cleaner, so that the commissioner was made a jurisdictional error without there being any pleadings, or the stress and strain aspect was not proved by them. But in my case, your lordship, it was the very case of the petitioner that he was on duty while pulling the while adjusting the load, while pulling the rope itself, he got stress and strain and he fell down and he died. The very judgment, your lordship, there is a causal link. There is crucial link between the causal connection of employment with death. Such a link with evidence cannot be matter of surmise or conjecture. If a finding is arrived at without pleading or legal evidence, the statutory authority will commit a jurisdictional error while exercising jurisdiction. There must be some evidence that the employment contributed to the death of the deceased. It is required to be established that the death occurred during the course of employment. During the course of employment was already established that he was on duty because he took the lorry to the transport company and he also exhibited his original driving license. And my lord, and the tribunal, your lordship, gave a plausible reason for considering that he died due to the stress and strain. Page 5 of the judgment, your lordship, last para. The argument of the learned counsel appearing for the second opposite party is untenable. There is no prohibition for a driver to adjust the load when the load was slacked. The duty which the deceased was performing was ancillary and incidental to his employment, and it cannot be said that the deceased did not die during the course of out of his employment on the ground that he was not driving the lorry in question. The deceased was engaged in driving the lorry in question by the first opposite party and he was on duty on the ill-fated day. A driver on duty on a vehicle must be deemed to be engaged in driving even though he was not actually at the steering wheel and the vehicle was not in motion at the time of the accident. Therefore, in view of the above circumstances and in view of the decisions, it is held that the deceased was workman as defined under the Act and he was employed for the trade and business. So, your lordship, there is no jurisdictional error committed by the commissioner because the very evidence and the FIR, charge sheet and the Panchnama report, everything speaks that the driver died while he was pulling the rope. The pulling of the rope is the resultant cause for the death of the workman being attacked by the heart attack. That stress and strain itself, your lordship, there, pulling of the rope. Had it been, he was not pulling the rope, just he was sitting in the cabin or sitting somewhere else, he got the heart attack. That is a different case. That judgment which my learned friend submitted to your lordship is applicable. But in this case, face of it, stress and strain can be visible. And one more thing, your lordship, though we have not filed the cross objections, but there is your lordship, the interest part only up to the in failure of the payment of the compensation within 30 days, interest was awarded. But your lordship, they are entitled for the interest from the date of accident.
It is there, no?
No, that is only up to failure of payment of the compensation within 30 days. That was during that time interest was not only after Supreme Court clarified that workman is entitled for
furnish that.
Yes, ma'am.
Furnish that.
Judgment I'll.
Because
Civil
we are-
charge case.
Postmortem report. Still there.
Postmortem, your lordship, cardiac attack, arrest. Cardiac arrest.
Cardiac arrest and martial fit.
They have not adduced any evidence that the accident is. Yes. CB charge
Furnish those judgment because we are not awarding.
No,
In
CB charge case, your lordship. CB charge case, the Supreme Court clarified that the workman is entitled from the date of accident in all aspects.
If the appeal is filed by the applicant, they are entitled.
Yes.
We are
I will give
But
that.
this is their appeal.
Yes.
Whether I can award.
Yes, I will give the judgment.
The date is done. Shall I post it on 15?
No, ma'am, I'm sorry, my lord.
When?
Martial fit.
Only for my submission.
Any other?
16.
17.
Okay, 17.
I'll submit. Bless.
1711.
One more case is also there in the same documents, but the quantum is different.
ఇంట్లోనేనా ఇంట్లోనా
That's it, that's not. It is like 73 also the same grounds now.
కూడా ఆయన పెట్టించుకో
Item?
73.
Item 73, yeah?
Only the underground is that, my lord, this, the quantum of, there is difference in the quantum. My lord, as per the old act, my lord, they are entitled to only 4,000 rupees. But in this case, 6,000 was avoided. There is the only difference. The remaining is fraction state. And in that, one of the aspect is that, my lord, the owner has nearly.
So shall I take up 73 or not? 73.
Yes.
Huh? But let us complete the list. We are still in.
This case only tax 40%. So that's 2 cases will be disposed of funds.
Okay. We are still in 36 now.
We wait.
I cannot skip all the council are waiting other councils. Yes. 37. 37 పిలువండి పేరు సురేష్ గారు ఉన్నారు.
Certainly my arguments. Other side will not come forward. The incident that we some there. Part of the interest in that. I to represent the council. Party.
No representation for the appellant.
Last time.
No. This is their appeal, no?
The incident appeal. I argued incident appeal.
Insurance.
Yes.
Sir, you are Suresh Kumar.
Suresh Kumar is other side.
You are Venkatesh sir. I got confused.
Venkatesh sir was what I represent.
Okay. Counsel for the appellant is present, but in the last occasion, no representation for the appellant only. Learned counsel for respondent is present.
They are not option.
No representation for the respondent. Learned counsel for the appellant is present. Counsel for the respondent is present. No representation for the appellant. No representation for the appellant and counsel for the respondent is present. Sorry, sir. Counsel for the appellant is present. No representation for the respondent. Hence, are any judgments issued, sir? As the cases of the year 2011 and the counsel for the, as there is no representation for the counsel for the respondent, it is posted under the caption for orders. For orders on 2111.
Lordship, I am for the appellant, Lordship.
Yes.
Lordship, this is a claim for 5 lakhs and award is 2,67,000 and odd. This is an injury case, Lordship. The appeal is filed by the insurance company. Only one ground that the commissioner has taken excessive disability while the medical record is clearly showing as 45% only. So in the net result is excessive award. That is the only ground, Lordship.
Other side. 45%.
Yes, Lordship.
55% fracture of left wrist margin. It has taken 60%. But other side counsel is not there. I will reduce that to some extent.
Yes.
Counsel for the appellant is present. No representation for the respondent on call. 1, 2, 3. 4th adjournment.
Can be passed on merits, Lordship, as your Lordship said. To
Hmm.
some extent can be considered and disposed of, Lordship.
But I have to hear the other side also, Kadama. For he heard the learned counsel for the appellant for hearing the respondent. Posted to 1511.
Against.
R1 unserved door lock. R2 served. This I can dispose of because R1 and R2. R1 is deemed service and R2 is also served.
Yes,
If you are ready with the arguments, you proceed.
Lordship, in the same matter, Lordship?
This one, 39, item 39.
Yes, Lordship. This is in regard to the ground shown as same, almost the same thing, Lordship. The disability is shown as 50% and the commissioner has taken 70%, which is 20% excessive, Lordship. And one point as a usual course, we say that no employment relationship been established on record. That is the only contention, Lordship. This also can be passed accordingly.
Agree. Satyamanjula garu.
Lordship,
Appeal is partly allowed to the extent of disability. From
much obliged.
60% to 55%.
Much obliged.
Partly allowed. Next.
40 K Venkateswara Shukla or Shukal Kumar.
పాస్వర్డ్ శీతలు ఎప్పుడు అది వేయాలి కదా అందులో ఒకవేళ పాస్వర్డ్
41 Ramakrishna Reddy, Ramakrishna.
Madam, this appeal is preferred by the insurance company, madam. It's a case of death, my lord. Mother and brothers of the deceased are the applicants. My lord, the case of the applicants is that, my lord, the deceased was employed as a driver. My lord, under the employment of OP number 1, my lord, on his tractor and trailer. And my lord, during the course of his employment, he sustained injuries in an accident and died out of those injuries. My lord, they claimed a compensation of rupees 6 lakhs before the commissioner. And the commissioner was pleased to award 5,33,468. My lord, in this matter, OP1, that is the owner cum insured, filed his counter, my lord, admitting the employment. And subsequently, my lord, the commissioner has taken the monthly wage of the deceased as per the GOs, my lord.
On what grounds you have preferred the appeal? Counsel?
You have preferred the appeal challenging the employer and employee relationship between the owner and driver of the crime vehicle.
Owner has filed the counter and admitted.
Yes, my lord.
Importance.
That is what we are submitting the facts, my lord.
Have you adduced any evidence at least? As usual? No evidence? Judgment answer.
My lord, actually, there are two claims, my lord. Lordship may, the order may be confirmed.
How? What is the amount awarded?
5,33,468.
Satyamanjula garu. Satyamanjula garu, have you filed wakalat in item number 42?
No, Lordship, I have not filed.
In the last occasion, you said the matters pertain to Naresh Bhairapaneni garu are allotted to you.
No, Lordship. Actually, Ramakrishna Reddy garu is taking care of his matters, Lordship. And few of the cases earlier, prior to that, whatever been allotted by these honorable benches, I was taking up, Lordship.
May I know the company, my lord?
New India Insurance Company.
We will take. May I permitted to have a copy, my lord? I will get it.
Sri A. Ramakrishna Reddy garu.
46 computer.
Item 42.
Computer code, my lord. 46. Otherwise, the name will not be reflected.
Is intent to file wakalat on behalf of the appellants. Actually, notices have been served to the respondents.
Well,
They are not contesting. No wakalat is filed on behalf
by
of
next date of hearing, we will.
Yes. Therefore, for filing wakalat. Ramakrishna Reddy garu posted to 23.
A copy may be.
23/11. Others pair. Insurance office.
It will take time, my lord. By next date of hearing, we will submit that. Otherwise, I'll get it Xerox.
Oh, I'm giving only spare copy. Immediately written back.
By lunch.
Next.
Matter posted to date.
23/11.
Oh, bless.
Lordship, I am for the appellant, Lordship.
Yes. Shravan Kumar garu. Ajay Shravan Kumar garu is not coming to court these days. No representation for the respondent and all counsel for the appellant appeared through hybrid mode. Posted to 24/11.
One humble request in this matter, Lordship.
Yes.
While undergoing all these documents, I have seen such a contradictory point. One such the grounds may not be sustainable for this present condition, Lordship. Earlier, they were telling that there is no employee-employer relationship, but as per the FIR, it is discussed under para number 11 that he was clearly stated as one of the laborer on the vehicle, accused vehicle. So, if it is considered as his employment is indirectly established as a laborer on that particular vehicle, may not be my appeal honestly sustainable, Lordship. In certain conditions, I don't think further argument is required for this case, Lordship.
Why don't you withdraw, ma?
Lordship, if I withdraw, there will be a lot of procedure will be there. If your Lordship can take as no merits, it would be very much comfortable to reply my client's Lordship.
Okay. Anyway, see, I have posted to 24/11. Let us see. Azhar Shravan Kumar garu is also not attending the court these days. On 24/11. Today we have disposed of many cases. On 24/11, we'll see.
Yes, much obliged.
42.
For respondent, you will also.
It is posted for the first time. Let us give opportunity. No representation for the appellant. Inform counsel for the respondent is present. And posted to 112.
Obliged.
When you connected, 45, 46, 47, 46. 45 to 58.
Today, the other matters were listed by launch.
Acha, all these matters, okay, together. These are all the matters, or some more cases are pending? Have you furnished those numbers, Amma?
These are yesterday's. The others are listed today.
What are the CMAs all
There
together?
are with regards to an arbitration OP that is dismissed in the lower court here. Basically, both the parties have an arbitration agreement. And it's of 2020 Your Lordship. We don't even know when the arbitration took place or anything. So we're trying to get information from the clients.
And then, see, we need other numbers also, so that difference of opinion, because what will happen is other cases will be posted in other courts.
Or other matters.
When are you going to furnish all the other numbers, Amma?
2311 is very posted, Yesterday also the matter they posted 2311 as fine. Furnished already.
2311. You are representing the appellant, no?
Appellant.
Counsel for the appellant's present. Yesterday also she stated that there are some other proceeding she took some what we have written. The first time, these cases are listed for the first time after 2012.
There are other
Posted. The counsel for the appellant stated that there are other connected matters. And for furnishing those case numbers, at request posted to 2311.
Just on the.
At request of the counsel for the appellant posted to 512. No representation. 512.
May I please, Your Lordship?
You are representing Ishwar Gara.
This appeal is preferred by the insurance company, my lord, matter arising under the Workman Compensation Act. So case of injuries, my lord, amount claimed is 3 lakhs. Commissioner was pleased to award 2,62,874. It's a case of injuries, my lord. My lord, the claimant's applicant, the case of the applicant is that, my lord, he is working as a cleaner. My lord, during the course of employment, he sustained injuries. My lord, to prove the employment, he examined the driver. And the OP number 1 has filed counter before the commissioner. My lord, now the only point involved in this appeal is that, my lord, the doctor gave a disability certificate, my lord, assessing the permanent disability at 40%. No, my lord, and the fracture injuries, the injuries sustained by the applicant, my lord, are non-scheduled injuries. And my lords may see the commissioner, my lord, without considering the same, has taken the disability, functional disability at 60% and calculated the compensation. My contention is that, my lord, it can be only restricted to 40%. As per the disability set.
Occupation of the applicant.
Cleaner.
Record is there. What are the injuries?
Issue number.
Number 21.
Para 9 also, doctor was examined, and as per the orthopedic surgeon, fracture of both bones, right leg. And an operation was conducted, develop small alignment and interior alignment. Yes.
And furthermore, the disability certificate is issued by Dr. G. Subhash Rao.
See, okay, that is okay. See, you dispute regarding physical disability at 40%, and as the tribunal has taken 60%. And what about to see the doctor has assessed loss of finding capacity at 100%, but the tribunal has taken only 60%.
My lord, the doctor who has given the disability certificate has never treated the applicant at any point of time.
Necessary. It's not necessary. There are a number of judgments by the Honorable Apex Court.
Confirm. Can be confirmed.
Because he's a cleaner. He has to climb the lorry, and the lorry cleaner means he has to climb.
My lord, in general sense, my lord, fracture injuries will heal over the course of time.
What is the age? Age of pain. After 30s.
Well, not with regarding to this matter, my lord, but these are my general submissions. The fracture injuries will heal over the course.
Have you adduced any evidence? Tell me.
No,
You can also
that is not with regarding to.
He can you can examine your company doctor, and he also can assess.
That is why, my lord. No, it is not with regarding to.
Steps.
It is not with regarding to this matter, my lord. My submissions are only now general submissions. The fracturing, the occupations and if he is a driver, that is a different issue. Subsequently, fracture injuries will heal. That is common thing, my lord. Your lordship is already aware. Generally, over the course.
If it is a regular employee like a labor, other things is okay. For a driver or a cleaner, he has to climb the lorry. It will be in a height. While getting down or boarding the lorry, it is difficult for them. In case if he lose the balance, he may fall down, and again those injuries which are not yet healed, they may again cause further trouble for the cleaner or the driver. If at all, I can reduce to some 5% or 2%. Or otherwise I can. By one Rahul challenge echoing judgments.
The orders. Blessed.
Appeal filed by insurance company. Appeal filed by insurance company. Case of injuries, dispute on liability, ground number 3. Ground number 3. The commissioner class whether the insurance or appellant is liable to pay compensation while the applicant categorically reported that he has been working as centering worker under respondent number 2, who has taken the contract work in piece rate with respondent number 1. Thus, it is clearly established that the applicant was not employed by the respondent number 1, Millard. He is worked in respondent number 2, a contract work. The page number 6, Millard, para number 3, page number 6. Page number 6, para number 3, Millard. On the 28/10/2004, the evidence of PW1 applicant was recorded in this court. He has stated that he has been working as centering worker under respondent number 2, who has taken contract work on fees rate with respondent number 1. He has further stated that on 2/1/2000 at about 12:30 p.m., where he was attending the centering work, the slab collapsed. He, along with others, police got injured. He has taken to the government headquarters hospital. That he is not related to any motor vehicle. He is not out of motor vehicle accident, my lord. It is only an incident of the accident, not accident, my lord. That we are not, the insurance company is not liable. Kindly to verify the insurance policy records. R1 insurance policy R1. Policy is on the name of G. Hanumantarao, my lord. But the appellant is worked in Popular Ramaswamy. The policy is issued on G. Hanumantarao, my lord. That he is worked in, the appellant is worked on in Akula Ramaswamy is the appellant number, OP number 2. He is not in employee, employer is not relation. There is no relation to OP1 and appellant to that.
For supplementary compensation act and then we can provide. Second, employer. Includes a body of person whether incorporated or not, and any managing agent, employer, and the legal representative of the deceased employers, and then the services of the government temporarily lent or let on hire to another person by the person with whom the workman has entered the contract of service or apprenticeship means such other person while the workmanship is working for it. 29. 17. Wait, next week. He's coming for alpha records.
My lords, item 75. Maybe posted 5th. Arbitration. Yeah. Published.
Item 17. Other side has been informed. Item 20.
Question tomorrow, but insist on day after tomorrow, will not happen. 6 and
1411.
First.
Okay, 2 minutes.
Section 2 was like any border process whether is covered or not. Any moving agent employer in the legal representative of the received employer and whether service software is temporarily lent or let on hire to another person by the person whom the workman has entered contract of service or apprenticeship with such work for 7% while the workman is working for him.
Insurance policy is issued on G. Hanmantarao Miller. He is the worker cold storage. But he is working, the appellant is working only Akula Ramaswamy, OP number 2 is the contract worker on the Akula Ramaswamy. That's why Miller. He is not employer, not relationship Miller. He is not worker in cold storage. He is only centering worker, contract worker. In the Akula Ramaswamy. That's why. Not Hanmantarao.
Sir, further hearing. Further hearing. Then item. This is item. 1511. 1511 for further hearing.
Robots.
Number 4, even group already. Which one?
No representation for this respondent. No representation either side and call. Wakalat is not filed by Sheetal Kumar Asta. For filing Wakalat by Shri Sheetal Kumar. Posted as a last is posted to 1611. For filing Wakalat as a last.
7.
Wait, please now. Application comes to then only one question. I would like to satisfy this to be lordship. Whether the decision is a bona fide passenger or not. Regarding for your lordship, already DR report has admitted that this is accidentally fell down from the train due to his own negligence by standing near the doors. That is already admitted in lordship. Now, only question before me is like, in this ticket is lost your lordship. So whether initial burden has been discharged by the deceased or not. Lordship, before going further,
I would like to list the conduct your lordship only on two aspects. The deceased, he was a CRPF constable, your lordship. He is a CRPF constable. He was posted in Muzaffarpur in Bihar state. He was a resident of Karnool district, your lordship. On the fateful day, your lordship, in order to join his duty to Bihar, he started from Guntakal, your lordship. Before going to his duty, he wants to stop at Bangalore to see his sister. This was the purpose of his journey, your lordship. His journey from Guntakal to Bangalore, around 567 kilometers, your lordship. He was sent off by his maternal uncle, your lordship, who was AW2 in the present case. Now, during his journey, your lordship, he slipped and fell down at Gutti railway station, approximately 57 kilometers after his journey. He slipped and fell down in the railway station itself, your lordship, between platform and the train. At the time of his fall, he was seen by the railway staff only, your lordship. At the time of his fall, they saw him, they called 108 ambulance, but by the time they were shifting him, he succumbed to the injuries, your lordship. These are the facts of the case. Now, only regarding bona fide, your lordship, kindly peruse the inquest report, your lordship. Exhibit A2, your lordship. Your lordship, this inquest report was attended by employers of the deceased, your lordship. Witness number 1, Mullah Sanjay Kumar. He is RMS office of your lordship. He is the railway person. Second, your lordship. Third is his wife. Fourth is his mother, your lordship. Kindly peruse the column number 7, your lordship. In the clothes column, your lordship. May I permit to read? The deceased wore military general uniform, which is mixed with light green, wheat, and yellow colors and shoes. Red color underwear, white color full banian. Right shoulder pocket of the deceased was open. In it, there is an identity card of the deceased with photograph. On the opposite railway track, from the place where the corpse is lying, there are leave certificate. Because he came to the station on the leave, your lordship. Leave certificate, as the deceased has to join the duty on 7/9/2007. SBI passbook, your lordship, ATM card, and some other papers scattered here and there. There is a black color travel bag of the deceased at the light pole, which is by the side of the corpse. In its closed small diary, in it address of the deceased, phone number, and some other numbers are written. They are collected. Now, your lordship, I would like to draw attention to column number 15. As seen from the contents of FIR, place of offense, state of corpse in the place of offense, injuries on the deceased, evidence given by the eyewitness and blood relation, as the leave is going to be completed, deceased wanted to go to Bangalore from his house to see his elder sister, and from there directly with a view to go to his duty at Bihar in the night of 2/9/2007. In fact, he has to join his duty on 7th, your lordship. His incident happened on 2nd. He reached Guntakal from Alur, and from there, with a view to go to Bangalore, he was traveling in Udyan Express. He accidentally slipped and fell down at Gutti railway station, mentioned in column number 7, and died. And the purpose of his journey, your lordship, was clearly mentioned in column number 22. He was working as CRPF and came to the house of Auto and he was joining. The same paragraph has been repeated, your lordship. What is the purpose of journey? And column number 20 says that he was dragged by the said train, your lordship. That train is known. Column number 21. Your lordship, this aspect says that the condition of the articles and condition of his disease says that there is every possibility of losing a ticket. That is my one submission here. Moreover, AW2 was examined, but in the judgment copy, his deposition was summarized to your lordship. Your lordship persists for deposition of AW2. In fact, there is nothing to summarize. Only 2 sentences are there in deposition, your lordship. The lordship persists deposition, your lordship. In his chief examination, your lordship, I have filed this affidavit. What I have stated in my affidavit is true and correct. The signature in the affidavit is mine. This is his chief examination. Coming to cross examination, your lordship, I do not know English. The contents in my affidavit are not explained to me. I do not know what I have stated in my affidavit. Only to this extent the affidavit is there. At a point he's saying that yes, I have stated in my affidavit are true. But my only contention is respondents other than this, they have not asked any single question whether are you present on that day, I mean giving him send off, which platform you were there, whether have you purchased a platform ticket, what is the fare of the ticket, where the deceased purchased the ticket, and what in the general ticket. No single detail was posted by the respondents to elicit because the name of the AW2 was clearly mentioned in the pleading statute saying that he has seen the deceased purchased the ticket. The same thing was confirmed in the AW1 deposition, Your Lordship. Your Lordship by peruse AW1. AW1 deposition, next page, Your Lordship. The last 3 lines. I deny suggestion that my husband did not purchase ticket. Along with my husband, my maternal uncle also accompanied. He informed me, but I have not seen my husband purchase ticket. I deny suggestion that I am giving false evidence. First, initially, when AW1 was examined, she told that my husband is the purpose of his journey. She told that I am not an access to purchase of a ticket, but my uncle, his paternal uncle, saw him purchasing ticket, and I learned from him. Now, when AW2 filed his affidavit, Your Lordship, and he said that in his chief examination that I know the contents of my affidavit, respondent posted one person saying that you do not know English, and he said that I do not know what are the contents in my affidavit. The next few other questions, no single question was put to him that how you are related to this case. And his affidavit is also not related by respondent in any manner. In fact, respondents are admitted that he fell down from the train due to his own negligence by standing near the door. At this juncture, Your Lordship, I would like to draw attention to the distance what he traveled. His total distance is 567 kilometers, Your Lordship. General presumption is that no person will travel for such a long distance without purchasing ticket because at every station, at every 20 kilometers distance, one TT will be there, Your Lordship. I'm just relying upon these citations, Your Lordship, which our Honorable Court has given. And prior to that, Madam. This is regarding burden of proof, Your Lordship. Abstract to Your Lordship, how the burden of proof of the deceased death of the passenger by accidental cause on the moving train. The relevant portion is para number 11, Your Lordship. If the onus would fall to this extent upon the drivers that he was not traveling on the train and had fallen down and thus was a victim of untoward incident, which aspects had also been recorded by the tribunal. Merely because no ticket was found from his body would not as such mean that dependents are not entitled to the compensation. The railway authorities would be under an obligation to check passengers, especially in the case of an interstate travel of a long distance, as it would not be expected that deceased would be traveling between Kalka and Ambala, which is at a distance of 60 kilometers. Therefore, keeping in view that the fact that provisions of section 124A are in the form of no fault liability, the drivers would be liable to pay compensation on account of untoward incident. Admittedly, the drivers had not been able to prove that their case fell within the exceptions or under so these are exceptions, Your Lordship. Now, I request Your Lordship to peruse para number 14, Your Lordship. No, this is para number 12, Your Lordship. Reference can be made to section 54 regarding the duty of passenger to the present his pass or ticket to such railway servant for examination during the railway journey or at the end of journey. Similarly, under section 55, there is a prohibition from traveling without a pass or a ticket. Section 54 and 55, these are the sections, Your Lordship. Now, column number 13, column number 13. Similarly, under section 137, there is a provision for a penalty of imprisonment up to 6 months if a person tries to defraud the railway authorities or attempts to travel without a proper pass. This section reads as under. fraudulently traveling, it has subclauses, Your Lordship. No. Your Lordship, card number 14, Your Lordship. In such circumstances, ticketless travel is an illegal act, and therefore it was for the railways authorities to check and detain an unauthorized person traveling without an authorized ticket, and a presumption would arise in favor of appellant that the deceased was traveling with a valid ticket from Ambala to Kalka and had covered majority of the distance before he fell from the train when it crossed Chandimanli railway station around 10 p.m. The onus thus should have been shifted on the railways to prove that he was a trespasser, as such was traveling without a ticket and not a bona fide passenger. Therefore, the tribunal has committed an error in dismissing the claim of petition of the claimant, and the improved order may be according to this result. Your Lordship, in this, there are Supreme Court citations that have been relied upon, Your Lordship. Based upon that, Your Lordship, 28th August, Honorable High Court of AP has stated the same. It's similar to the present case, Your Lordship. The same similar citation have been in the present. Our Honorable Court has given one more judgment based upon the same citation, Your Lordship. Para number 7 is the reference. Statement para number 7, Your Lordship. It is set in law in the view of various judgments that a passenger may not be allowed to enter a platform if he does not possess a platform ticket. It is admitted fact that there will be train ticket examination for all the trains, and number of such TTs will be more in on superfast train and reserved compartments. It is highly difficult for a person to travel long distance from Bangalore to Nirdawood, where the accident occurred without a ticket. We cannot avoid such an examination check by the TTE right from the Bangalore to Nirdawood. He had crossed more than half of the journey by the time of the accident. There is no dispute that this is for traveling in second class reserved compartment. Therefore, it shall be deemed that he was having a ticket, thereby he was a bona fide passenger. The singular judgment has been relied upon, Your Lordship. There is a case where articles will be found but accept the ticket. But he has covered half of the journey, say from the Bangalore to Nirdawood. In the present case, on the same thing, Your Lordship. My only contention is, Your Lordship, AW2 did not. Initial burden as for Reena Devi is like there is an initial burden on the claimants by filing the affidavit by mentioning the relevant facts of the case. Here we have filed 2 affidavits by mentioning different facts. But the respondents only one question they posted when AW2 was brought to the court. No single question was put to him saying that how are you related to the present case? Were you present on the day? No such efforts were put by the respondents in any manner, either in DR report or because DR report is filed after 1 year after filing the claim application. That means they are within the knowledge that the name of the AW2 is present in the file number 6 of the pleading. They have not examined it then or also when he came before the court. Further, Your Lordship, based upon the articles, how they are scattered and the distance restricted, Your Lordship, there is every possibility of losing the ticket and he cannot travel to such a long distance without purchasing the ticket, Your Lordship.
Pasha, may kindly see the AWS 1's evidence, Your Lordship, page 3 of the judgment, Your Lordship. My husband was working in Bihar. I have not filed the claim case in Bihar RCT. I have not filed in Bangalore RCT either. I have only filed in this RCT. In the year 2005, my husband had gone to Bihar. In August 2007, he had come back. My husband used to come now and then to Kurnool. I used to sign in Telugu and I learned to sign in English about 2 years back. I also signed in Telugu as C. Lashmi. In 2006, I signed as Lashmi in the ration card. I admit that there is no stamp of the Tahsildar in the ration card and I am not aware that it is necessary. It is true that in the ration card, my mother-in-law's name is also mentioned. My mother-in-law lives with me and my husband was her only son. She is also a dependent. My mother-in-law is alive. I did not accompany my husband. He purchased a ticket for Udayan Express from Guntakal to Bangalore. I was not an eyewitness to the incident. From the telephone diary, the police informed me on phone at about 2:30 in the night on 3/9/2007, Your Lordship. The AW is not eyewitness to purchase the ticket and also the incident, Your Lordship. And also, Lordship, may kindly see the next page, Your Lordship. AW2's evidence, Your Lordship. Examination in chief. I have filed this affidavit. What I have stated in my affidavit is true and correct. The signature in the affidavit is mine. In the cross-examination, Your Lordship, I do not know English. The contents in my affidavit are not explained to me. I do not know what I have stated in my affidavit. Regarding this cross-examination, Your Lordship, I relied on the full bench judgment of this Honorable Court, Your Lordship. Honorable Court, Your Lordship. What is the evidentiary value of the AW2's evidence, Your Lordship? In all cases, whether appealable or non-appealable, the examination in chief has to be conducted by way of affidavits. In cases where the witness is not under the control of the party who wants to examine him as a witness, recourse can be taken to Order 16 Rule 1, and after taking recourse to Order 16 Rule 1 of CPC and after he is summoned by the court, the witness can be asked either to file an affidavit or can be examined in the court itself. In such case, it could not be said that affidavits presented to any court are not at all governed by the Evidence Act in terms of Section 1 and in terms of Section 3. It is not included in evidence, and that therefore interpretation cannot be placed on Order 18 Rule 5 that examination in chief can be filed by way of affidavits. An affidavit is merely an affidavit when it is filed in the court, but when a witness appears for cross-examination, it is necessary for the witness either to confirm or differ the contents of the affidavit. After his confirmation or denial of the contents of affidavit, whatever recorded is the evidence, and if the witness conforms to the affidavit would become part of the statement made by the deponent before the court. Therefore, what is finally taken as evidence by the court is not the affidavit, but what is contained in the affidavit if confirmed by the deponent when he appears before the court for cross-examination. But in this case, Your Lordship, he is not confirmed by the affidavit, Your Lordship. As per the cross-examination, I do not know English. The contents in my affidavit are not explained to me. I do not know what I have stated in my affidavit. But what exactly in this judgment, Your Lordship? What is finally taken as evidence by the court? It is not the affidavit. But what is contained in the affidavit, if confirmed by the deponent when he appears before the court for cross-examination. And also, Lordship, may kindly the paragraph 5 of the judgment, Your Lordship. Per contra, by filing written statement, contentions raised in the OA were controverted by stating that no journey ticket to travel from Guntakal to Bangalore was found with the deceased. Therefore, he was not a bona fide passenger. There is no eyewitness to the incident. The act of deceased amount to self-inflicted injury, and he fell down due to his own criminal act, falling within exception within class B and C below provisional section 124A. It is the Mullah Sanjeev working as RMS department, postal department Guti, RS, who attended train number so-and-so at 15 hours on 3/9/2007 to receive tuple from the postal compartment of RMS, and after departure of said train, noticed a person on the track and shifted him to platform, and then reported to Deputy Superintendent SS Guti, RS, RPF personnel, who was deployed to inquire the details of said person. Reported the deceased was not a bona fide passenger of said train, Your Lordship. Actually, also my contest is just AW2 is evidence is the crucial, but they have stated the applicant as per the applicant contest, Your Lordship, AW2 is the eyewitness to purchase the ticket. But my contest is, Your Lordship, but as per the cross examination of the evidence of the AW2, Your Lordship, he don't know about anything regarding the purchase of the ticket, Your Lordship. That is my contention. And also, Your Lordship, there is no eyewitness to the incident also, Your Lordship. That is my contention.
AW2 said that I do not know the contents of my affidavit because they are in English, but AW2 never said that I did not see any person of ticket. That question itself was put to him. Regarding the case, no single question was put to him. So he did not deny anything regarding the case at all.
Does it? Forty. Item 40. Item number 28. Enara?
Notices. And coming up service, not by the capture loss note down. This one number 84286. And 30th itself, August 16.
Yes.
It's found that
Notice served to R2.
the other side last minute, no one is filed vocal. When the case is his father who is not the founder of pleading. They are not attending the appearance. That it has to be allowed. Fact that the department side they didn't file any counter. R2. That's a complete when we restore the food.
Records. List is directed to call to records immediately from the consent point posted to 1st December 112. ఇందాక శీతల్ కుమార్ మనం 16 పట్టింది. మార్నింగ్ అడిగారు బుచ్చిరెడ్డి గారు కౌన్సిలర్ at request of the council for the respondent posted to 4th December 4th 63 and 68 V. Krishnara okay 4th December. Sixth December.
Requested two things.
1st December. 1st to 4th. No representation last month. Posted to 5/12. No representation either side. No representation for the appellant and for counsel for the respondent is present. Posted to 5/12. Morning they have requested. Counsel for the appellant is present. No representation for the respondent call. Hence posted to
Your
5/12.
lordship's kind permission, lordship. I prefer the respondent in this matter, your lordship. Item number 70, your lordship.
In item number 70, is the counsel requested you, Amma? Is he informed regarding adjournment?
We were informed during the course of the time, your lordship. Course of
Yes.
the day. Yes, your lord.
Okay, 5/12.
Oblige, your lordship.
72.
No representation for the respondent call. At request of counsel for the posted to 1/12.
73, 30, 20. Until the other place. Yes, market time. There's no error. We report 150 by the The aspect is that cannot. So if you want to find the counter denying the employment. Employment of the disease. And the birth infection, it's infection. Each of the judgments. Each of the bigger.
Para 8, there are no paragraphs for the order?
Yeah, no paragraph.
Then how can you say 8th paragraph? Page 2, huh? Okay.
The OP. 1, 2. OP further stated that it's for article concur. And for the third reason, we inject the service from opposite party. So further, came to know that on the day of death, this is came the result from the Talgan Commission. In order to meet this paragraph, and during the discussion, the usual reported to the police that he got this screen and become unbound. This was the affidavit filed by the owner of filed by the owner. I not I expect that I not. The lower court had taken the income as stolen from. Whereas my lord, for the act, my lord, they are entitled for only 4,000, that is stealing.
Have they filed it? Salary certificate is filed?
Then, owner itself has denied the retirement, my lord. And there is no salary certificate filed.
No salary certificate. Okay.
As per act, my lord, they are entitled for only 4,000, that's a maximum. For this ancient purpose.
Based on the Minimum Wages Act, the tribunal might have taken
In the
by applying
the case disposed.
relevant due.
The maximum ceiling is 4,000 as per the act. Even in yes, there's no article possible. But in that case also, my lord, I will consider it's only 4,000. Plus, as per the act, the ceiling is 4 for the time. So, my lord, there's the interest of 2,000 rupees for 2,000 rupees. And that has to be shared.
Yes, counsel for respondent.
I'm for the rest. Your Lordship may see, first of all, the substantial questions which they have framed are not the substantial questions of law. The appeal is not maintainable unless the substantial questions of law are framed. Your Lordship may say, whether the labor court not erred in coming to the conclusion that the disease died during the course of his employment and there was a relationship between the disease and the opposite party, number 1, respondent number 5 as employee and employer at the time of the accident, in view of the fact that except the oral evidence of the applicant number 1 as PW1, no corroborative evidence is produced, including the evidence of the person who gave complaint to the police. This cannot be said to be the substantial question of law. It is a question of fact. Basing on the evidence, the court has given the finding that disease was an employee. And second question also, my lord, whether the learned commissioner is not erred in coming to the conclusion that the disease was working as a driver on the insured lorry, in spite of the admitted fact that the disease left the services. There is no such admitted fact. The very framing of question, not a single scrap of paper, shows that there is an admission in spite of admitted fact that the disease left the services. He never admitted, and no evidence is produced on that aspect. On the said lorry as a driver 3 months prior to the date of accident, and thus question of functioning as a driver by the disease as on the date of accident and died during the course of the employment under OP number in arises. This is also pure question of fact, not a question of law, my lord. So all the questions which they are formulated in the grounds are the questions of fact, and questions of fact have been answered by the court tribunal. The third, the learned commissioner is failed to consider the averments made in the counter filed on behalf of the opposite party number 1, owner of the crime vehicle, crime lorry, that previously, though the disease were working as a driver on his lorry, his services were dispensed with prior to the date of accident for the reason that the disease was a habitual drinker, though OP number 1 not entered into the witness box for inquiry. So the counter averments have been raised as a questions of fact, and they themselves admit that OP number 1 had entered into the witness box. The learned commissioner is not erred in considering the wages as 6,000 per month in the absence of any corroborative and comprehensive evidence, both oral and documentary, since it was contrary to the law prevailing at the time, and in the absence of any proof of income, the learned commissioner is not erred in considering the same at 4,000 per month, and whether the commissioner not erred in awarding the excess amount. So, my first submission, my lord, none of the questions framed as substantial questions of law in this appeal cannot be said to be substantial questions of law, and they are the only questions of fact. And the questions of fact, that too based on the counter filed by the opposite party number 1. When he filed the counter, mere filing a counter will not establish the case. He has to adduce the evidence. Neither he cross-examined the witnesses, my witnesses, nor he produced any evidence. So merely relying on the counter filed by the opposite party number 1, opposite party number 2 cannot take any advantage of that fact. He ought to have examined in support of his contentions, whatever unto that. And the proof that he is the driver working in the opposite party number 1 is established by the documentary evidence. FIR was lodged by the very employee of the opposite party number 1. When the opposite party number 1 employee lodges the complaint stating that he is the driver of that vehicle, no contrary evidence is produced. And FIR is lodged because the reason a telephonic message has been sent by the cleaner that
the person who is driving the vehicle as driver of the vehicle was not keeping good health. He has a heart problem. Then another driver was made arrangement. So that is the reason from Kurnool to Hyderabad, while coming to that, though he drive the vehicle, but by coming up to the Langar house, he could not in a position to continue the driving. He stopped the vehicle, and when he want to about to take some rest, he died. So that is the effect of the heart attack. In the course of employment, he had heart attack, and that is established. There is no contrary evidence that he died due to any other reason, and that too was not in the driving duty. The judgment, Your Worship may take. On behalf of page N of page 10, my lord, on behalf of OP number 2, Sri Abhijit Dubey, AO of the insurance company, adduced the evidence by way of chief affidavit, 24 July 2022. In his affidavit, the OP2 stated that the deceased died due to heart attack. Their own witness, examined as a OP number 2, his own witness, Abhijit Dubey, says that OP2 stated that deceased died due to heart attack as per the complaint, FIR and final report. The vehicle was not involved in the accident and OP2 is not liable to pay compensation. The OP2 witness further stated that the vehicle was in the name of Jamshed Khan and later transferred to Syed Moin Ahmad, and there is no employee-employee relationship between the deceased and the OP number 1, and there is no liability on the part of the OP number 2, and requested to dismiss the case. During the cross-examination by the applicant counsel, he stated that he was not eyewitness to the incident, and he also accepted that on the date of the accident, the insurance policy was in force and was in the name of OP number 1, and he do not know whether Sergeant Travels is owned by OP number 1. The applicant filed written arguments and reiterated the same as mentioned in the application. Though they are eligible for more compensation, but because of the huge court fee, he claimed only 5 lakhs as compensation. On 7/5/2007, while the deceased was driving the vehicle and coming from Karnataka with cement load, suddenly fell ill due to severe heart attack after reaching Reliance Petrol Pump, Langar House, Hyderabad, and he stopped the vehicle to take rest. During the course of his employment, the cleaner who was with the applicant informed about the incident to the OP number 1 by telephone. The OP number 1 deputed another person by name Rashid Khan to drive the vehicle. So from Karnataka up to Langar House, the deceased was the person who brought the vehicle. So when he got the information, he arranged another person, Rashid Khan, to drive the vehicle. By the time the other driver reached the spot, the driver died. So by that time he died. The police Langar House registered a case with crime number 197 of 2007. The deceased was drawing 6,000 as monthly wages and 50 per day as bata. The dependents of the deceased was issued a legal notice, so and so the OP number 1 received the legal notice but failed to furnish any details of the insurance, and also not paid any compensation, and no reply was issued to the legal notice. That is another aspect, my lord. Before filing the case, when a legal notice has been issued to the opposite party number 1, at that time he did not deny that he is not the driver. On the other hand, your employee given a complaint stating that he is the driver of that company. As per Exhibit A1, which is first information report by the police station Langar House, in which it was stated that Shri Rashid Khan, an employee of the Sergeant Travels, made a complaint to the police, to the co-employee on same person, he lodged, in which he stated that M.A. Yusuf, deceased, was an employee of the vehicle number AP 2090 7889. The OP number 1 in his counter stated the deceased was not his employee, whereas he did not deny the complaint made by one Rashid Khan, who is the cleaner as per the police report. As such, there is an employee and employer relationship between the OP number 1 and the deceased, and to avoid the payment of compensation only, he denied. So basing on this material before the court has come to the conclusion that deceased was the employee, and there is a relationship of employer and employee between the parties. Otherwise, they could have produced any documentary evidence or entered into the witness box that with whom that vehicle was interested. The vehicle who coming from Kurnool to Hyderabad was undisputedly being driven by the deceased person. And during the course of his job only, he got the heart attack and he died it. As per FIR and the police report, the vehicle number AP 2090-7889 came from Karnataka with cement load, which driven by the deceased. The deceased stopped the vehicle at the Reliance petrol pump, Langar House, while on duty. He stepped down from the vehicle and sat under a tree by the side. He unexpectedly laid down. He was shifted to the government hospital where the doctor declared him brought dead. As said, the deceased died due to the heart attack while on duty due to stress and strain, which is contended by the applicant counsel. The dependents of the disease are justified in claiming the compulsion under the Act. So, driving is nothing but it is a duty of stress. Because of that thing, there is a chance of getting a heart attack. And on account of that only, he died it. And it was on his duty. He is dutied from Kurnool up to Hyderabad of his place. He has to discharge the duties. So, my submission, my lord, while he was in the duty, discharging the duties, he died it. And the court below had rightly concluded and gave a finding. And in fact, my lord, the minimum wages act also, your lordship may take. So I have claimed compensation of that, but the driver comes under the skilled labor, my lord. For that, 6,999.75, that is 7,000 will be minimum.
Actually, date of accident is 2007.
Which year?
You will also be the High Court direction is also in view of the interim direction of the Honorable High Court in WP number so and so, suspending the operation of GOMS so and so, the minimum wages of the year along with VDA as per the revised GO so and so are shown. This is shown as per that.
Year of accident is 31/12/2007. Year of accident. Actually, the tribunal also has directly taken the wages. See, salary certificate is not filed. OP number 1 has not entered into the witness box, but still has taken the salary at 6,000, stating that the minimum wages prevailing at that point of time, but not has stated. I just wanted to have that minimum wages in the year 2007.
4319 is the minimum wages. As per the Act, my lord, the flag is 4,000.
Your lordship may the
The
interim directions of the High Court was in respect of the
Whether it is retrospective or prospective telling.
GOMS, your lordship may GOMS, it pertains to that GOMS 54. It is of 22/6/2007. That was the subject matter.
I understood, sir, but it is paid from 1/10/2016 to 31/3/2017. Actually, this court, in the absence of salary certificate or no evidence, we are taking 4,000 or 4,500.
4,000 is the maximum amount.
In the absence of salary certificate or the evidence by the opposite party.
No, my evidence is uncontroverted. Your lordship may hear in this case, there is no contrary evidence to the evidence which I have stated. Apart from that, I stated that data is also there. So that is not disputed.
You are not, you have any proof before the ending.
Record is there with us.
You ought to have examined the employer if that is the case. In the absence of the employer's evidence, my evidence has to be taken into consideration.
1 minute, we have the evidence.
Your lordship may say that.
It is the flag. They cannot go beyond that. Even if they have proved that it is the is earning 10,000 rupees also. They are entitled to only as per that. As per the World Act.
In my chief also I have stated, my lord, my deceased husband was drawing a monthly salary of 6,000 per month and a bata of 50 per day. Now, this aspect is not disputed in the opposite party number was not at all cross-examined. So this fact has to be taken into consideration. My chief affidavit, in the absence of any contrary evidence and no suggestion was given, this is false. So this has to be taken into consideration. 6,000 per month, because being the wife, she knows that this is the.
She cannot go beyond that. Amount cannot be awarded beyond that. As for the World Act, matter, they are entitled to only 4,000 rupees. In order to be kindly produce the World Act. Between the amendment, it was enhanced to 6,000. And later it was enhanced to 8,000. The 2006 matter, the act is limited to 4,000.
No, that Geo, my lord, it is with effect from GOMS 54, 22/6/2007. Your lordship may take notification issued by GOMS 54 dated 22/6/2007. 2007 that Geo was there, and that was the subject matter of the writ petition. In view of the interim direction of the Honorable High Court in WP number so and so, suspending the operation of GOMS so and so, minimum wages along with VDA as per the revised so and so data are shown.
I will wait.
So that Geo of 2007 says that minimum wages would be 7,000. But apart from that, the evidence on the record in the shape of petitioner's evidence, oral evidence, it is not questioned by the employer. So in the absence of any.
And not file any proof before.
Yes, I have seen. In the cross-examination, suggestion has been put.
Suggestion was there.
Suggestion was there.
Cleaner was very much there in the vehicle, but they have not examined the cleaner.
So you're saying that they have not examined nor what evidence has been adduced by the insurance company, sir?
No, my lord, it is them to do the owners.
They have discharged their initial burden.
My lord, it is the owners is there on the tickets to do that.
Yes, they have discharged.
The person heart attack and do that both of them.
They have stated many aspects. They have discharged, and it is for the rest. Anyway, it's rejection.
Your lordship, I am relying on certain citations also. Yes, sir.
Court of
Your lordship may here para 11, the first respondent remain ex parte, because it is the case of ex parte in our case also, that is the relevancy. I have given the first respondent remained ex parte before the labor commissioner. The claimant claimed himself as the driver engaged by the first respondent. No rebuttal evidence was produced on the side of the respondent. No witness was examined and no document was marked on the side of the respondent. Hence, it is decided the claimant was working as a driver on the first respondent and that the appellant has failed to prove that section 3 of the Workmen Compensation Act was not applicable to the present case. All the questions raised before the appellant court are not questions of law, they are only questions of fact. This is one decision. The second decision, my lord, regarding this is also, it may be page Para 5, my lord, it may be noticed that the claimant respondent number 1 categorically asserted that her husband, the deceased Gangaram, suffered heart attack on account of strain of work. The claimant respondent number 1 examined herself in support of her assertion as above. Her statement indicates that the employer respondent number 2 had no second driver and therefore her husband, the deceased Gangaram, was required to work overtime, as a result of which he was under great strain and suffered from heart attack, which proved fatal. The respondent number 2 has not stepped into the witness box to rebut the assertion and the statement as above of the claimant respondent number 1. That the statement as above of the claimant respondent number 1 has remained virtually unchallenged. Therefore, the death of the deceased was due to the accident arising out of and in the course of his employment. Para 7, with reference to the above contentions may be made to the division bench judgment of the Guwahati High Court in National so and so. In that case, the driver of the truck was sent by the owner of the truck for delivering consignment. On the way, truck had to stop on account of strike. At night, after taking meals, driver of the truck slept in the cabin of the truck and died. Claim was preferred by the wife and mother of the deceased before the Commissioner for Workmen Compensation. An objection was raised that as the driver of the truck died a natural death, it was not an accident and compensation was not payable under the Act. The Guwahati High Court repelled the contention as above. It was held that as the deceased had gone to the spot where he died in the course of his employment, and death was as a result of the causal connection between the incident and the employment, and the death occurred in the course of his employment. Therefore, it was an accident within the meaning of the Act. Similarly, in the state of Rajasthan versus Man Kanwar, so and so, a forest guard died due to heart attack while on duty. The postmortem report revealed that the cause of death was shock due to acute myocardial infarction. The claim petition filed before the Commissioner for Workmen Compensation was opposed by the employer, and it was contended that the death of the forest guard was not as a result of the accident. It was held that the deceased had to work overtime and he was on duty. Therefore, it was held to be an accident arising out of and in the course of his employment. It was therefore held that the compensation under the Act was payable. Similar view was expressed by the Madras High Court in so and so, which again was a case of death by heart attack due to excessive strain of work. So all these citations goes to establish that during the course of employment, he died. The another Dear my lord, it is also case of heart attack only, arising out of and in the course of employment. Workman driver was driving the oil tanker during the entire night and reached his destination in the morning, where he complained of chest pain to the cleaner, became unconscious and died. Investigating officer filed document in which he mentioned that the deceased died of heart attack and proved postmortem report. Commissioner found that doctor who conducted postmortem has not been examined, and claimant failed to prove by leading evidence that deceased died of heart attack induced by the heavy stress and strain of work. Whether there was a causal link between the duties discharged by the deceased and his death, and it was caused due by the stress and strain, held yes. It was not necessary for the claimant to examine the doctor in view of the material placed on record. Deceased used to drive the tanker even at odd hours, and the very fact that the deceased was working as a driver of oil tanker, his job was full of stress and strain. Case law discussed. Then it also covered that wages, daily allowance, whether daily allowance paid to the driver has to be added to his income for the purpose of computing compensation for his death, held yes. In this also, my bata is also there. I have stated in my chief affidavit. So another. This is covering the bata. Whether the bata payable by the rate should be included. Principle of assessment bata. Whether bata payable to the deceased should be included for determining his income and consequently amount of compensation. Held yes. Bata is paid towards meeting the personal expenses of the driver. This is another. Lastly, And one more decision. What is that? Fair wages is also covered by this decision, my lord. In para 19, fair wages mean the rate of wages payable to the motor transport workers specified in the schedule to this act, or the agreed rate of wages, whichever is higher. So even if the fair wages as fixed in the act is less, but what is paid is more, then whichever is more, that should be taken into consideration as per the decision, my lord. So my contention is that 6,000 was the wages, and apart from that, bata is payable. So my submission, my lord, the appeal is liable to be dismissed. In fact, I am entitled for more amount what the lower court has granted that. For that also, I am entitled, and the law is well settled that if I am entitled for more amount, the court has power to grant that amount also. Yes. Reserved. Reserved.
May I please, Lordship? Lordship, kindly have it next week, Lordship. Senior had some throat infection.
Council both sides are present at request of the council for the respondent. Posted to 2111.
Obliged.
Council for the appellant is present, no representation for the respondent. Hence posted to 2111. 23rd.
My lord, appearing from respondent, my lord. My lord, respondent counsel requested after 2 weeks, my lord.
Lakshmi Prasanna.
Yes, my lord.
And you
Yes,
are
ma'am.
representing Chandrasekhar Garu? Yes. Both council. At request council posted to 2411.
Blessed. Blessed.
LC record వచ్చింది. Await both council present. Await LC records
Spite
posted
of direction is given, they are not.
21.
లాంగ్ అవసరం నేను చూస్తాను ట్రై చేస్తానులేండి సార్ ఈసారి
What is the CMA?
మేడం సిఎంఏ కమిషనర్ హాస్ గివెన్ ఫైండింగ్ దట్
It's not WC or
WC
case.
yes Hyderabad WC workman compensation Hyderabad local only their contention is the deceased, according to me the deceased was the driver of the tractor, but insurance is saying that one Prasad was the driver, he was changed in the place. That is their contention only. In order to ascertain the truth, and now the honorable court called for the lower records. The owner himself admitted and has given evidence. There is entire evidence on record is there. But my learned friend is.
It will become again a question of fact only.
Yes, that
regarding this.
This is the case. The father of the deceased has said that he was carrying that basket, lunch box to the driver, and he was sitting beside the car. And all of a sudden, my lord, the version was changing to he was driving the vehicle.
No, man.
This cannot happen.
It is the clear question of the fact, my lord, and my humble submission. It is the clear. అవును ఎక్కడైనా వేసుకోవచ్చు jurisdiction while they
That is the basic document that has to be filed. Because that is being there, that is there, they won't file in the court.
The police clearly filed the final report and the entire statements of the witnesses have been recorded, and the owner himself came to the court and filed counter and adduced evidence. He himself that this deceased was the driver. Only their contention, because the father, admittedly the father had given report to the police after the accident, but he was not present at the time of that accident. Somebody, on hearing somebody, he has given the complaint stating that deceased was driving, but in fact the deceased was himself driving that vehicle, and the co-driver and another driver was also examined by the police, and his statement also has been recorded that I am at a different place at that I am not at the. This is the clear question of fact, Miller. Only on that aspect they are disputing. There is no substantial question of law at all. There is no substantial question of law.
20-11.
Yes, ma'am.
Await LC records. Both counsel are present. 22.
20. Deeply obliged. I will. లేదు సార్, నేను తెప్పిస్తాను సార్, ఇక్కడ అవసరం వస్తుంది అడుగుతాను, ఎందుకంటే చాలా అది.
Okay.
Deeply obliged.
Next. 79 at request of the counsel for the appellant posted to 30-11 37. 112 వేసాం. 112 వేసేసాం 80. నెక్స్ట్. No representation for the revision petitioners on call. Counsel for the respondent is present. And posted to 512.
May please, Miller.
80.
Miller, I am for the respondent, Miller.
84-85 in the morning. Appellant has requested time, but I have not addressed the matter.
Sorry, Miller. This Honorable Court already fixed the time for final hearing, Miller, in the month of April, Miller. Since then, today, they are seeking the time, Miller. The respondent every time ready to argue the case, Miller. But appellant enjoying the stay orders, he did not turn up to argue the case, Miller.
But it is a 2022 case.
My submission, Miller, the respondent is the senior citizen and physically handicapped and is facing several ill health problems, Miller. That's why I request the.
No, actually, what happened is this case is listed for the first time before this court.
Yes, Miller. That is true, Miller. But see the earlier docket, Miller.
Both counsel are present at request of the counsel for the appellant posted to.
Any short date may be given, Miller.
30-30-11.
November 13. Some conditions, Miller. Otherwise, they are not under.
To 22 matter, how can I give conditions, sir? We are taking up 2007 matters.
Yes, that is true, Miller. I am not denied, Miller.
If there is any urgency, definitely I'll take up even 23 cases also. If there is any urgency.
Yes, Miller.
To at least convince the court.
Yes, Miller. I filed expedited petition, Miller, saying the urgency. All the respondents
are. It is not there, sir. It is not there.
Expedited petition filed, Miller.
No.
That is allowed by Justice M. Lakshman, Miller, in the month of April.
Anyway, on 30th we'll see. We'll give, because first time it has been listed. We'll give an opportunity later on.
Much obliged.